senior counsel Arun Shyam antanu ಮಾಡಿ ಅದನ್ನೇ ಮಾಡಿದರೆ in case he wants the evidence other things any other he is not you are not in challenge he has challenged it.
Yes, my lord. My lord, only thing is, my lord, in the written statement we have our counter claim and we have also produced the schedule, my lord, where movable
They have
properties
not
are part
said
of the
anything. If there is any other order passed, please come. Yes. Next.
77 minutes day after tomorrow. The other side has filed objection. Tomorrow I have no objection. Tomorrow I have no objection.
ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
My lord, it is application for rejecting of the
Order 7.
plaint has been rejected.
Plaint rejected. Plaint is rejected.
Rejected. Plaint has not been rejected, sir.
ಮತ್ತೆ
Their application is.
My
application
my
rejected.
application
Plaint
has been
rejected and ಇಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ? Yes.
ಅಲ್ಲ
DMCPC.
ಅಲ್ಲ ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಗೆ CHC ಬರೋದಿಲ್ಲ ಅಂತ.
Oh, commercial court ಅಲ್ಲ.
ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್.
It was heard in the morning partially.
What's the matter?
tomorrow ಮೇಲೆ ಸ್ವಲ್ಪ objection ಹಾಕಿದ್ದಾರೆ.
ಇವಾಗ ಕೊಟ್ರ objection?
ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೆಳಿಗ್ಗೆ.
The morning I've served it on them.
ಮತ್ತೆ ಓದಕ್ಕೆ ಬೇಡ. Thursday. Admission. Admission preliminary hearing. Preliminary hearing. Yes.
But one submission in the previous, my lord, the leave of the court, my lord. Not let the both the, my lord, suit decided together, my lord. Because
P&SC ಆಗಲ್ಲ ಸರ್. Ayan is.
No, we will cooperate, my lord.
No,
both
no,
the
he's
parties.
crying
Otherwise,
foul
my lord,
saying ಮಕ್ಕಳಿಗೆ ಎಜುಕೇಶನ್ ಇಲ್ಲ ಅಂತ.
1/3 share ಅವ್ರು ಕೊಡ್ಲಿಕ್ಕೂ ರೆಡಿ ಇದ್ದೀನಿ. Section 8 of the Hindu Succession Act.
same schedule, my lord, is called in question. My lord, it is inter-alia dispute
Except
between
3
the
of
parties.
us, there are no other legal heights.
It is
Lord,
his. One
if
inch,
the
sir.
P&SC, my lord, the
It is
separate.
his petition. You have not challenged the order.
No, we have not challenged, but your lordship, my lord, let it go, my lord, parallelly, my lord,
ಅದನ್ನೇ ನಾನು ಹೇಳಿರೋದು ಬೇರೆ
ಅಲ್ಲ,
ಏನು
together
ಹೇಳಿದ್ದೀನಿ?
ಅಂತ ಆಗ್ಲಿ ಅಂತ ಅಷ್ಟೇ.
ಬೇರೆ ಏನು ಹೇಳಿದ್ದೀನಿ?
ಅಲ್ಲ, P&SC ಗೆ ಮಾತ್ರ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ.
No, no, whichever is concludable, let it get concluded. ಅಷ್ಟೇ ಹೇಳಿರೋದು.
Let both, my lord, be concluded together.
I have no objection. 6 months.
Partition suit 6 ತಿಂಗಳಲ್ಲಿ ಮುಗಿಸ್ತೀರಾ ಸರ್?
ಮುಗಿಸ್ತೀವಿ ಸರ್.
We create history.
ಇಲ್ಲ, only 4 ಇಷ್ಟೇ ಇರೋದು, limited schedule and only 4 parties are there, my lord.
ಆಯ್ತು, ಎಲ್ಲ ಸೇರಿ 3 ಮುಗಿಸಕ್ಕೆ ಹೇಳಿ.
ಅಷ್ಟೇ, ಹಾಗೆ ಮಾಡಿದ್ರೆ.
ಅದೇ ತರ
Let it not be prejudice any. Wait.
Let's hear for the petitions. That's plaintiff's writ petition. That's trial court is granted an order of injunction, but it's not to obstruct the road. That's the appellate court has modified the order.
Modify ಮಾಡಿದ್ದಾರೆ. So
Modified insofar as 3 to 6 are concerned. That's now they are obstructing the road. But the sketch has been produced minutes in page 58. But the sketch has been produced minutes in page 58.
serve on the respondent. The petitioners shall serve on the counsel.
Already served minutes. Served and caveat has been filed and already
caveat
served.
ಇಲ್ಲ?
Idare.
ಬೆಳಗ್ಗೆ ಇದ್ರಾ?
Illa minutes. They are not appearing.
Counsel for the caveat is not present both in the forenoon and in the afternoon. In that light, status quo be maintained by the parties till the next date of hearing.
That's already gate has been fixed minutes. Now he has not allow the petitioner to enter into the land.
Status
So,
quo
sought for
ಅಂತ
stay of this order of the appellate court.
Right, in that light, the order of the first appellate court shall remain stayed. Yes.
Much.
Next. Oh, no, emergent notice to the first respondent. Yes, next.
89.
Nodu, let's see, day after tomorrow. Next.
101.
ನಾನು ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
101.
This matter, respondent in this matter.
Yes, sir, Microsoft
Just
Corporation.
one statement
Ratika
before
wait.
I ಅಲ್ಲ ಇನ್ನೊಂದು ಏನೋ ಬೇರೆ ನಾನು I have to tell something, Lord.
ಓಯ್ ಆಚೆ ಕಡೆ ಮಾತಾಡ್ಕೊಂಡ್ರ ಮತ್ತೆ
Something I have to say.
No, I have to bring to Lordship's notice something. The reason why we are before you. But this matter, Lords, there is a dismissal of the plaintiff. When the matter came up before the trial court, both of us appeared before the trial court. It was argued for some time on the application. Then my learned friend appeared and filed an undertaking saying that we will not preserve the records and said that undertaking should not be published. That was the undertaking given. At that point of time, I agreed. But now when it transpires, if Lordships have to see the court order,
court order cannot
court
be
order
published.
says court order should not be published. The difficulty which I am facing, I must bring to Lordships. But this matter is quite widely watched.
No,
by
whatever
all other
widely
persons.
watched
There is
or
a likelihood of it being
loudly
published.
watched, I am not
No, the
concerned
reason is,
about that.
there is a
1
reason.
minute, sir.
No, I wanted to clarify something. If this is published by somebody else, I lose this interim order goes. Therefore, this order
No,
is
no,
quite
one moment. What is that order?
I want to say something.
Not to court order should
May I
not be,
just say
which
something?
court has accepted this submission of yours?
Not my submission,
Then-
I'm sorry.
It is an agreement between both parties.
What agreement? That
It was-
court order also will not be
They will
published?
not publish, they will not.
Agreement that
it was-
court order also will not be
They will
published?
not publish, they will not publish it. They
What-
will not publish it.
It is on the website, sir.
No,
No, they
no,
have
no,
not
please
been
appreciate
uploaded.
this. No, no, sir, 1 second.
He doesn't upload it. to
Mr.
the
Navagi, please wait 1 minute. I have to finish this. This is not, in my humble submission, Lord, I consider this proceeding itself an abuse of process. Because what happened in that day was, it was an understanding everyone came to. My learned friend, Lord, is right. He called his client, asked her this specific question, because this order was, no, please, 1 minute, Lord. Grant me 1 minute. I normally, my Lord, will never say this. It is a question of propriety of the petitioner coming before your lordships today. Because the petitioner was present before the court on that particular day. It was not as if my submission was recorded and that became an order of the court. The petitioner was asked, are you willing to do this? Petitioner said yes. Only then was this order passed. Therefore, I'm filing a memo, my lord.
Now, the answer, 1 minute. Insofar as your undertaking or the undertaking of the petitioner that she will not publish,
That's all right.
that's no problem. Court order should not be published.
But what
By
is the
her.
law?
By her. My lord, what
That is
happening?
not the indication
My
of
lord,
the
please,
court.
1 minute. Your lordship,
If that
grant
is
me
the
1 minute.
indication of the order,
Let's
that
see
is
the
fine.
order. Please take this. My lord.
It's only by her, then no problem.
My lord, I
Is
want
it not published on the website?
Or if anyone else publishes it, my lord, I want to tell you, lordship, someone else publishes it, it's a different matter.
Yes.
This entire litigation is only made for media publicity and media circus.
I
There's
deny
nothing
all
more
the-
to
What's
it.
the
I
matter
want to
about-
make a statement. So
No, no,
once
this-
media circus,
I
there's
deny
nothing
all
more
the-
to
What's
it.
the matter
I want to
about-
make a statement. So
No,
once
no, this
again.
is not the way.
No, no, you can't
Lord, I have
also say
been
these
thrown-
things.
Lord, I
I'm
was
sorry,
one
with
of
all
the
due
most
respect to you.
senior most serving executive, chief
No,
executive
no,
of
It's Microsoft Corporation.
How
No, no,
you-
she's not the
And
senior most.
unceremoniously, my lord, but the kind of
He resigned.
harassment,
No, no, this.
kind
Lord,
of harassment I
I'll
wonder.
get back to you, sir. The answer.
Kind of harassment she has been
Microsoft.
subjected to. Throughout, not gag orders were passed. Throughout, gag orders were passed against me. But in fact, the records would show you, if you do not resign now, we will dismiss you with certain charges, etc. Anyway, all those is matter of record. It is at that point of time, but I am chiefly aggrieved by this one. Now, but kindly look at my situation. The court says do not publish its order. But in fact, the law is,
No, court, see, now the answer is clarifying it, saying that we never said that court should not publish. You should not publish.
but kindly look at.
You don't publish. You're given an undertaking that you don't publish, don't publish.
But my only apprehension is this one. This order is likely to be published by third party. The difficulty,
No,
difficulty.
if it is published, interim order would get vacated.
Yes,
Even what is the
that
order
is the
here?
difficulty. That is the difficulty.
Where is the order?
But kindly see page number 37.
So you'll get it published by someone else.
So I may not, that is the allegation they are going to make it. No, this is therefore
Obvious,
No, but this matter is watched. That is why, sorry to repeat it.
because it is keenly watched.
No, the reason is, no, the reason, sorry. In fact, this was always published throughout. These proceedings have been published.
See, proceedings is a different thing. Now, the order of the things is a different thing. Now, the order of the court cannot be hidden, all right? It has to be published on the
Kindly see,
website
it's
or whatever it
almost
is.
like my learned friend today saying, please stop the live recording of this. It's almost like saying this.
You're
But
asking
kindly
that.
see the law.
I have not
Kindly
yet
see
said
the
anything.
law
I'm
in-
keeping
no,
quiet
I'm-
now, my lord. Since my learned friend is arguing, I'll keep
no.
quiet, but I want to say many more things.
What is it? See,
No,
look
kindly
at
see
Jan,
the law,
I'm
the
keeping quiet till now.
Till my learned friend finishes, my lord. Then I will say
Kindly
a
see
few
page
things.
number 37 first.
Yes, yes. Hmm. Of what?
No, impugned.
First, let me understand the controversy. You are dismissed,
No, yes.
resigned. all right.
Our case
One
is,
minute, you have resigned from service. Now, what have you challenged before
we
this?
have sought for damages as the plain relief and for a
Damages.
declaration. this
What
is
is a declaration of
that
what?
this amounts to constructive dismissal.
All right. Hmm.
These are the two reliefs we have.
What is the injunction that is
Injunction,
granted?
interim application we filed was, there was series of correspondence between Microsoft US and here, which showed the kind of intimidatory tactics or exchange of mails between the parties, which ultimately resulted in this impugned order. I said, please preserve those records, because if those records were in their possession, please preserve those records. But the matter
No,
was,
correspondences by electronic mail.
yes,
ಅದು ನಿಮ್ಮ ಹತ್ರನೇ ಇರುತ್ತೆ.
ಅಲ್ಲ, ನಮ್ಮ ಹತ್ರ some of them are internal, which they
Oh,
did not.
internal
Some of them
correspondences.
some of the head of them, but there's a huge, there was a huge commotion. I was called for an inquiry, all those. Anyway, my lord, coming back, but then what this matter, interlocutory application was filed.
Hmm.
I argued for some time. My learned friend thereafter appeared and said that we are giving an undertaking. That undertaking said, please do not publish this undertaking. And
No, nor publish the order of the court until further orders.
Yes.
That's not.
Let
Although,
my
what is-
friend finish, my lord.
only- Allah,
I
very
have to
good.
say
Allah.
something, I will
No,
say.
there is a,
I don't want to say
kindly see
anything.
the law on this point.
Law,
Kerala High Court judgment.
then law,
No, yes,
nor
to the-
publish the order of the court, you can't do that
I
at
mean,
all.
no, the question
That-
was.
I don't think
I am
the
not-
answer will
Lord,
subscribe to
I-
that view.
I am not subscribing to a view, my lord, that the court order can't be published.
Huh.
I am only speaking of what happened on that day and what is the statement made by a party to a court. Now, if
No,
the,
no problem.
so
If-
far as they are concerned, they can't. If someone else publishes, of course they are entitled to publish it.
Yes.
There's no question. There's no question. Anyone else can publish it. Not that I can't place a restraint in an inter partes
to-
proceedings on a
Alright.
third party.
No, no,
इसी के साथ आज का समाचार समाप्त हुआ.
kindly see the undertaking.
No, no,
ಅಷ್ಟೇ.
This is subject to,
ಇನ್ನೇನಿದೆ ಹೇಳಾಯ್ತಲ್ಲ.
very well,
I,
very well.
ಮತ್ತಿನ್ನೇನಿದೆ ಸರ್?
Lord,
Very
anyway,
well,
Lords, we
very
keep
well.
this
Third
memo on
party is to publish.
record in
But
this
you
proceeding.
get,
The only
you'll get it published with
That is the only
everybody.
apprehension, but I'm happy.
In every,
Yes,
in
yes.
every single article which has come out, the petitioner, plaintiff has given her own statements as to what happened in court proceedings. That is the danger.
Not
You
after
want
the
to,
court.
I'm sorry, sir, I have all the articles.
now
Now,
she
if you-
will not.
Now, I
Not
kept
after the
quiet.
court proceedings.
Of course, after the court proceedings in Delhi, this matter was originally filed in Delhi. Then about 15, 20 articles came in every newspaper possible from Financial Express. All of them are obviously at the instance of Latika Pai, who makes in every single one a different comment as to what the legal proceedings are, how she was harassed, how she was humiliated, and all of those. Therefore, when we said this is the first date of hearing before the court, I came up and told the court we will not do anything. We will preserve whatever is there in record as on that day. But you also give an undertaking that you will not publish it or speak to the media about this order of the undertaking. Immediately, my lord, and in all fairness to my learned friend, my lord, he called the petitioner, asked her, and she said yes, she will not. And then, Lord, the statement was made. At that time, also a similar submission was.
Guru, Nale, Lord, what the, I mean, now that he's saying all things off the record, the learned presiding officer.
Off the
also-
record.
No. What happened? No, the presiding officer said if it gets published by any circumstances, your interim order will stand vacated. These were all
Order ಇಲ್ಲ.
order illa, but these are.
ಅದು oral.
The undertaking.
Therefore, my lord, because this writ petition.
So oral orders from local presiding officers
No, my lord,
should not matter.
because of
They
this
were-
writ petition which came, I had to file a clarification application before the court. I filed an application seeking clarification as that it was by consent.
ಎಲ್ಲಿ?
I filed an
Now
trial
here-
court
for
here
the
is it.
trial court.
This nothing to do.
No, in the which, my lord, we had to say everything that transpired in court.
ಅಷ್ಟೇ.
Lordships may observe that, the third part.
Someone else does it, no, I have no objection.
You
Lordship.
can't do. Okay.
I also can't. I'm just saying, it was never my intention,
Well, yeah.
nor was it the intention of the court at that point in time.
But one more request, and this, Mullards, in all fairness and transparency, the order, Mullards, is not being uploaded in the website. Now, this some sort of, and this is such a plain order of dismissal. I do not know what is so secretive about
I have it, it's uploaded.
You have not
There is the order
downloaded
sheet.
perhaps.
ಇಲ್ಲ,
It is uploaded, you have not downloaded.
ಹೇಳಿ, no, you upload ಆಗಿಲ್ಲ, ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ, ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ, ಮಾಡಿಲ್ಲ ಅವರು ಸಾಹೇಬ್ರು.
ಇಲ್ಲೇ ಇದೆ.
ಅದಕ್ಕೆ ಟೇಕ್ ಡೌನ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆಯಾ?
Right.
So ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ. I mean, it has not been uploaded. I know that much.
He is saying it is there.
No, it is not. ಇಲ್ಲಪ್ಪ. ಅವ್ರು
ಒಂದೇ ನಿಮಿಷ.
app
Sorry. ಅಲ್ಲ ಬೇಕಾ?
It is on the app. my lord, it is
It's
put
there,
up
no?
On the app, but it is not put up on the website.
No,
Hey,
it is
that's
there, I have it
website,
here.
sir.
Both the e-courts app, it has been uploaded. my
On
lord.
the
But it is
e-courts
not-
app, it is there. I
It is
read the
there.
order on
It-
the e-courts app.
It's accessible on the net.
The statements being made by the council concerned that it is not there,
Even then I don't have a doubt. Yes.
then I have that.
ಟೋಟಲ್.
ಅಷ್ಟೇ ಅಲ್ಲ? The petitioner is before this court calling in question an order dated 9/6/2025 passed by the Court of Session in OS 3982 of 2025 concerned court ಅಂತ ಮಾಡಿ 2025. The bone of contention is the order. The order reads as follows. The order is indicative of the fact in its on a perusal at its first blush that the order of the court also should not be published as is passed on IA1. A further reading would indicate, or it is needless to observe, that the order of the court should not be published by the petitioner as the petitioner had undertaken not to publish the undertaking given by the first defendant pursuant to which the aforesaid order is passed. While the undertaking given by the first defendant cannot be published, as that was a part of the undertaking. And the
I'm sorry.
Alva.
There is nothing on record that we have given undertaking, but I agree. In the order, my lord, it doesn't say it is undertaking, but I agree, my lord, that we undertook.
That's all right.
I'm just.
The counsel, the learned senior, respective learned senior counsels appearing for the parties would submit that the taking that the plaintiff shall not publish the undertaking given by the defendant number 1, nor publish the order of the court until further orders. The words "nor publish the order of the court" cannot be read in isolation. It has to be read concerning the plaintiff. The publication of the order shall not be made by the plaintiff is what the order would mean, as it cannot mean that the order of a court cannot be published. The said clarification would suffice for the present is what the learned senior counsels, respective learned senior counsels appearing for the parties would submit. In that light, the undertaking of non-publication is only relatable to the petitioner and not to the order passed by the court. I will not say somebody else, not to the order passed by the court. With the aforesaid observations, the petition stands disposed. Yes.
The IA is still pending, bro. The application is still pending.
Whatever.
Yes.
It is the concerned court is at liberty to regulate its procedure further.
Great. Great.
So for us 2 to 7, we'll give them up.
ಇದೆ ಇಶ್ಯೂಗೆ ನಿಮ್ಮಿಬ್ಬರಿಗೆ ತಾನೇ ಬೇಕಾಗಿರೋದು.
Undertaking is only given by one, not the others. Great.
124.
ಅದೇನ್ ಬಿಡಿ ಅವ್ರೇನೋ 41 ಲಕ್ಷ ಕಟ್ಬೇಕು ಅಂತಾರೆ, ನೀವೇನು?
Yes, my lord, they have to pay.
ಅಲ್ಲ, ಡೈರೆಕ್ಷನ್ ನಿಮಗೇನೋ ಕೇಳಿದಾರೆ ಅವರು.
Yes, my lords, kindly turn to page number 20, my lords. It's a relinquishment deed.
List it on Thursday in preliminary hearing.
Yes,
Next.
much.
ಆಯ್ತು ಹೇಳಿ ಮೇಡಮ್. ನಾಯ್ಡು ಸರ್. ರಜತ್, which is yours?
139.
Further hearing.
Let's kindly be taken on Friday, my lords.
Lords, this is 27 times, my lords, they have conveniently misled this court.
Misled?
Please, my lords.
What is misleading?
Problem is this, my lords, the
Today,
FIR.
my lords, IA for vacating still.
ಅದೇನೋ ಹೇಳ್ತಾ
My
ಇದ್ದಾರೆ.
lords, at his request only.
You wait, sir.
Please, I have not requested.
Yes, Rajat.
My lords, there are 7 matters which are tagged together.
Correct.
5 crimes have been stayed by this honorable court,
Huh.
of which in 4 cases, my lords, there is a common petitioner. And my lords, the investigation is of the year 23. And that is, my lords, every time, my lords, I am requesting
Offense ಏನು?
My lords,
420,
all
406.
406, 420.
406, 420.
My lords, at the previous instance, learned senior counsel had submitted that consortium of people targeting one person with the help of one retired police official, my lords.
Retired police officer.
Retired police official. I purchased a property from one lady to be,
One ready
one lady, my lord.
lady.
Yeah. My lords, my humble submission would be, my lords, learned senior counsel is not well. Today, just a moment ago, I confirmed that sir is
ಯಾರು?
Ravi Shankar sir.
All right.
ಅವರು
Not well.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಸರ್ ಇವತ್ತು ಬೆಳಗ್ಗೆ IFR ರೈಟಿಂಗ್ ಸ್ಟೇ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಫ್ರಮ್ ದ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ಅಟ್ ದ ಬೇಸ್ಡ್ ಆಫ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಿಮ್ಸೆಲ್ಫ್.
Obviously it based on the complainant.
ಅಲ್ಲ
State ಗೆಲ್ಲಿದೆ
I will
ಅದೆಲ್ಲ.
file a formal objection, it may be taken, my lords.
ಏನ್ not necessary. We'll
Finally,
hear it. When will Ravi Shankar come?
Friday or any other date under, my lords, so
Any day
We'll repeat it.
in the
Wednesday and Friday, both days it will repeat.
Wednesday.
in the morning, my lords, may I
Wednesday
request
and Friday, both days it will repeat.
on top
But
of
you
the-
finish all your work and come at 4:30.
Please, my lords,
Please,
my lords, my only request that on the previous date, my lords had directed for the investigation papers to be brought before my lords, that I.
ಒಂದಿಲ್ವಾ? The learned HCGP to secure the investigation papers and place it before the court on the
My
next
only
day.
request, my lords, let it go on subject to my lord's order.
ಆಯ್ತು, ಫ್ರೈಡೆ ಮಾಡಿ.
Wednesday.
2 ವರ್ಷದಿಂದ ಸ್ಟೇ ಸಡನ್ ಆಗಿದೆ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, my lords,
Here
we
ಮಾಡ್ದೆ.
have traveled, my lords, to Dharwad, to the other rosters and then.
Problem.
ಇಲ್ಲ my lords, ಅಂದ್ರೆ we will finish, my lords, I was so eager to wind it up, my lords, because
ಅದಕ್ಕೆ.
there is nothing in that. There is
If you have objection for that, I'll release it if you want. Not a problem.
I have nothing.
no,
my
no,
lords.
no,
I go down to my
Friday,
lords.
Wednesday at 4:30. Grateful.
Red flags, my lords.
ಎಲ್ಲಿ ಸ್ಫೂರ್ತಿ 1,26,000.
41.
Madam, today they have filed a memo of calculations, madam.
I'll also explain.
ನಿಮಿಷ ಇದು ಬಕೀರಪ್ಪ ಎಸ್ಕೇಪ್ ಆಗ್ಬಿಟ್ರಲ್ಲ ಇಲ್ಲಿ. ಹಾ ಎಸ್ ಒಂದೇ ನಿಮಿಷ ಎಸ್.
ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ 2024 ಅಲ್ಲಿ
I just want.
ಅಲ್ಲ ಇದು ಸೀತಾರಾಮರಾವ್ ಸರ್ ಬಿಡಿ ಆಲ್ಸೋ ಸಿಂಗ್ಸ್ ದಿ ಸೇಮ್ ಸಾಂಗ್ 41 ಲಕ್ಷ ಕಟ್ಟಬೇಕು ಅಂತ.
ಅವ್ರು ಕಟ್ಟಬೇಕು ಲೋಕಲ್
ಅದೇ ಅದಕ್ಕೆ ಗುರುವಾರ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್
ತಗೊಳ್ಳೋರು ಅವರು ಅಲ್ಲ ಅದನ್ನ
ಥರ್ಸ್ಡೇ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ದೀನಿ. ಎಸ್ ಮೇಡಮ್.
Your Lordship, I would like to place.
ಲಿಸ್ಟ್ ಆಫ್ ಅಥಾರಿಟೀಸ್.
Synopsis
What
and.
happened to your hand? Huh? ಹೌದಾ? You're all right. Yes. You're all right. Yes.
I've called out the entire series of incidents that has taken place, Your Lordship, in this, which is called a greater prejudice.
ಈಗ ವಾಪಸ್ ಜೈಲಲ್ಲಿ ಇದ್ದಾರಾ?
He is in jail since 2 years, Your Lordship.
2 ವರ್ಷದಿಂದ.
ವರ್ಷದಿಂದ.
He's ಏನ್ ಕಾನ್ಸ್ಟೇಬಲ್?
Constable, police constable. Now he is the sole.
Police
breadwinner.
constable behind bars.
Unfortunately, Your Lordship.
Oh. Unfortunately. Yes, ಹೇಳಿ ಮೇಡಮ್.
Your Lordship. The
ಇರಿ ಸರ್.
Next week ಹಾಕೊಂಡು.
ಯಾಕೆ ಬರೀ ಇದೇ ಆಯ್ತು?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಬೇಲ್ ಕೊಟ್ಬಿಡ್ತೀನಿ ಈಗ.
ಅಲ್ಲ ಸೀನಿಯರ್ ಇಲ್ಲ ಅದು.
ಬೇಲ್ ಕೊಡ್ತೀನಿ ಈಗ ಹಾಗಾದ್ರೆ. ಈಗ ನಿಮ್ಮ ಆಬ್ಜೆಕ್ಟಿವ್ ಅಚೀವ್ ಆಯ್ತಾ? ಜೈಲಲ್ಲಿ ಇದ್ದಾರೆ 2 ವರ್ಷದಿಂದ. ಇದು ಪ್ರಾಮಿಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಅಲ್ವಾ? ಫಾಲ್ಸ್.
That's their allegation, Your Lordship. But
ಎಷ್ಟು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
Your Lordship, 2019 prior to October is the alleged relationship. But
The whole
the
problem is the orders written by the coordinate bench.
I understand.
Can't get over that.
There is no observation as to merits of the case, Your Lordship. The only fact that has caused so much of prejudice is the